Hey everyone, welcome. I am absolutely thrilled to have you here for this explainer. Today, we're undertaking a very special construction project together. But don't worry, we aren't building a house or a skyscraper. We're going to dynamically, step by step, build our understanding of English contract law, specifically tailored for the ACCA corporate and business law syllabus. If you're someone who likes to see exactly how complex concepts snap together perfectly like a giant puzzle, well, you are absolutely in the right place.
Here is our roadmap for this explainer. We'll start with the origins of English law, then look at interpreting statutes, map out the anatomy of a contract before breaking down offer versus acceptance, consideration and intention, and finally, capacity and certainty.
But before we start laying down that foundation, I want you to think about something. Do you know the exact moment a casual promise to a friend or a colleague suddenly snaps into a strict, legally binding obligation? It's a genuinely fascinating threshold, and by the time we wrap up this explainer, you're going to know exactly where that invisible line is drawn.
Okay, let's dive right in. Section 1, Origins of English Law, or simply, where the rules actually come from.
To understand contracts, we first really need to understand the bedrock they sit upon. English law doesn't just spring from one single place. It actually flows from three main sources. First up, we've got statute law, which is primary legislation made directly by Parliament. Think of things like the Companies Act. Second, we have common law. This is made by judges through precedent. For example, historic case law on negligence. And third, we have equity, which was developed way back by the courts of chancery to handle things that needed a fairer touch, like trusts and injunctions.
Now notice the strict hierarchy here because this is absolutely crucial. If there's ever a clash between these rules, statute law prevails over common law, purely because Parliament is sovereign. You definitely want to lock this single line into your memory. Statute beats common law, and common law beats equity. It is literally the ultimate trump card in the English legal system.
Speaking of common law, let's talk about how judges actually make it. They use a doctrine called stare decisis, which basically means stand by what has been decided. But here's the catch. They don't have to follow every single word a previous judge mumbled. They only follow the ratio decidendi, the actual binding legal reason for the decision. Lower courts absolutely must follow this. Anything else the judge might have just mentioned in passing, that's called obiter dicta, or things said by the way. Obiter dicta might be persuasive, sure, but it is never strictly binding like the ratio decidendi is. Moving right along to Section 2, Interpreting Statutes. Let's look at how judges actually read the rules. So Parliament makes the supreme statutes and judges make the common law. But what happens when a judge has to read and apply one of Parliament's rules and the wording is just, well, confusing? Judges actually use a very specific escalation process to figure out what a statute means, and it brilliantly illustrates the balance of power in law. Step 1 is the literal rule. They just use the ordinary dictionary meaning of the words. But if that creates a completely absurd result, they move to Step 2, the golden rule, to modify that literal meaning just enough to avoid the absurdity. If it's still muddy, they escalate to Step 3, the mischief rule, where they step back and ask, what specific problem, or mischief, was Parliament actually trying to fix with this act? Finally, if all else fails, they use the purposive approach, looking at the much broader purpose behind the legislation. It's basically a step-by-step toolkit for decoding the rules.
All right, Section 3, Anatomy of a Contract. This is the master checklist.
Now that we've got a rock-solid understanding of where the rules come from and how they're read, let's shift our narrative to physically building a business contract. The crucial takeaway here is this. A contract isn't just a piece of paper with some signatures on it. It's a legally enforceable agreement that requires every single one of these 6 elements. And here is a massive exam trap to watch out for. If you're analyzing a scenario and even one of these blocks is missing, the entire contract crumbles. The whole shebang. There is no valid contract. You need all 6. So let's start assembling them.
Section 4, Offer versus Acceptance. Let's call this part the handshake.
Let's zoom in on the microelements, starting with the first 2 essential pieces, how parties actually form an agreement. Imagine you walk into a store and you see a shiny new laptop sitting on the shelf with a ridiculously low price tag on it. You grab it, you're super excited, but ask yourself, is that price tag a legally binding offer? Can you literally force the shop to sell it to you at that price?
Well, the answer is no. Drop the hammer on this concept right now. Goods sitting on a shop shelf are not an offer. They are what's known as an invitation to treat, which simply means they are an invitation for you to make an offer to the cashier.
The actual legal offer happens when you take those goods up to the checkout and the shop accepts your offer when they ring it through the till. This was famously established in the case of Pharmaceutical Society v. Boots. It's an absolutely vital distinction for sure. So, once a valid offer is out there, it needs an acceptance, a final, unqualified agreement to the terms. But when does acceptance actually kick in? It depends entirely on your method of communication. Under the famous postal rule, if you mail a physical letter, the acceptance is effective the exact moment you drop it in the postbox. Boom, contract formed. But for instant communication, like an email or a fax, the acceptance is only effective when it is actually received by the other person. Oh, and remember, silence can never, ever constitute acceptance.
Section 5, Consideration and Intention. This is all about the actual exchange.
We have our offer and our acceptance. Now let's move to the next building blocks, focusing on what is actually being traded. Block number 3 is consideration. This is basically the price of the promise. It's something of value given in exchange. The rule here is fascinating. Consideration must be sufficient, meaning it has some legally recognizable value, but it absolutely does not need to be adequate. You can legally sell $1 million house for $1 single if you really want to. That nominal value is sufficient. However, beware of another major exam trap. Past consideration is no consideration. If you promise to pay someone for a helpful act they already did last week, well, that's not valid consideration because the act is already in the past. It just won't hold up in court.
Block 4 is the intention to create legal relations. How does the law view hardcore business deals versus simple family promises? It relies on presumptions. In a commercial agreement, like in the Edwards v. Skyways case, the law heavily presumes you intended to be legally bound. But in domestic agreements between family members, like a husband promising maintenance to his wife in Balfour v. Balfour, the law presumes there was no intention to be legally bound unless you clearly wrote it down. It really turns dry legal hurdles into a pretty interesting story about human relationships, doesn't it?
Almost there. Section 6, Capacity and Certainty. Let's snap those final pieces into place.
Block 5 is capacity. Who actually has the legal ability to sign a contract in the first place? Well, adults have full capacity. But for a minor, someone under 18, a contract is voidable for non-necessities, though it is still binding for basic necessities of life. And if someone is mentally ill or, say, heavily intoxicated, the contract is voidable only if the other party actually knew about their incapacity at the time. And finally, our last block, Block 6, is certainty. The terms of the final agreement must be absolutely clear and complete. If the terms are vague or up in the air, there is no contract at all. It's really that simple.
Okay, let's bring this whole explainer full circle. If you want to absolutely master the formation of a contract for your ACCA LW exam, burn this simple equation into your mind right now. Contract equals offer plus acceptance plus consideration plus intention plus capacity plus certainty. If you miss even one, the whole thing falls down.
So I'm going to leave you with this final thought. Now that you intimately understand this strict 6-part legal checklist, take a look back at your own life. How many of the casual, everyday agreements you've made just this past week would actually survive a court of law? It kind of changes the way you look at a simple promise, doesn't it? Thank you so much for joining me in building this knowledge today. Keep studying, keep analyzing those cases, and I'll see you next time.